Welcome to EUPrivacyForAll, Session 59 on GDPR, Article 83, Administrative Fines. Article 83, replacing Article 79 on the general conditions for imposing administrative fines, lays down that each supervisory authority shall ensure that the imposition of administrative fines pursuant to the GDPR shall in each individual case be effective, proportionate and dissuasive. Those administrative fines shall, depending on the circumstances of each individual case, be imposed in addition to or instead of corrective powers of supervisory authorities. When deciding whether to impose an administrative fine and deciding on the amount of the fine, in each individual case, due regard shall be given to the nature, gravity and duration of the infringement, taking into account the nature, scope or purpose of the processing, as well as the number of data subjects affected and the level of damage suffered. The intentional or negligent character of the infringement, any action taken by the controller or processor to mitigate the damage suffered by the data subjects, the degree of responsibility of the controller or processor, any relevant previous infringements, the degree of cooperation with the supervisory authorities, the categories of personal data affected by the infringement, the manner in which the infringement became known to the supervisory authority, and whether the controller or processor notified the infringement itself. In case measures referred to in the article related to corrective powers are previously been ordered against the controller or processor, compliance with those measures, adherence to approved code of conducts or approved certification, and any other aggravating or mitigating factor applicable to the circumstances of the case, such as financial benefits gained or losses avoided directly or indirectly from the infringement. If a controller or processor intentionally or negligently infringes several provisions of the GDPR, the total amount of the administrative fine may not exceed the amount specified for the gravest violation. In the following paragraphs of Article 83, three buckets of amounts of fines are framed. First, infringements could be subject to administrative fines up to 10 million euros or in case of an undertaking up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher, in case the obligations of the controller and the processor have been infringed, notably regarding processes, documentation, technical and organizational measures, risk-based approach, and certification, the obligations of the certification body, or the obligations of the monitoring body regarding codes of conduct have been infringed. In the second bucket, going up to 20 million euros, or in case of an undertaking up to 4% of the total worldwide annual turnover of the preceding financial year, are the basic principles for processing being infringed, including conditions for consent, that is to say, principles, lawfulness, consent, or special processing provisions. The data subject's rights pursuant to Article 12 to 20, the transfers of personal data to a third country or an international organization, any obligations pursuant to member state law adopted regarding special processing, or non-compliance with an order or a temporary or definitive limitation on processing, or the suspension of data flows by the supervisory authority. Finally, non-compliance with an order by a supervisory authority shall be subject to an administrative fines going up to 20 million euros or 4% of the total worldwide annual turnover, whichever is higher. Without prejudice to the corrective powers of the supervisory authorities, each member state may lay down the rules on whether and to what extent administrative fines may be imposed on public authorities and bodies. The exercise by the supervisory authority of its powers shall be subject to appropriate procedural safeguards, including effective judicial remedy and due process. Where the legal system of a member state does not provide for administrative fines, this article may be applied in a manner that the fine is initiated by the competent supervisory authority and imposed by competent national courts. In any event, the fines imposed shall be effective, proportionate, and dissuasive. Recital 148 lays down that in a case of a minor infringement, or if the fine likely to be imposed would constitute a disproportionate burden to a natural person, a reprimand may be issued instead of a fine. It shall be subject to appropriate procedural safeguards, including effective judicial protection and due process in any case. Recital 149 stresses that member states may lay down the rules on criminal penalties for infringements of this regulation, and those criminal penalties may also allow for the deprivation of the profits obtained through infringements of this regulation. Those penalties should not lead to the breach of the principle of ne bis in idem, as interpreted by the Court of Justice. Recital 150 finally leads that in order to strengthen and harmonize administrative penalties against the infringements regarding the GDPR, each supervisory authority should have the power to impose those fines, with due regard in particular to the nature, gravity, and duration of the infringement and of its consequences, and the measures taken to ensure compliance and to prevent or mitigate the consequences of those infringements. Additionally, administrative fines being imposed on persons that are not an undertaking, the supervisory authority has to take account of the general level of income in the member state as well as the economic situation of the person in considering the appropriate amount of the fine. It should be for the member states to determine whether and to which extent public authorities should be subject to administrative fines. Recital 151 finally announces that the legal systems of Denmark and Estonia do not allow for administrative fines as set out in the regulation. Article 70 on the tasks of the European Data Protection Board announces that the board shall, on its own initiative or where relevant at the request of the Commission, draw up guidelines for supervisory authorities concerning the fixing of administrative fines. Article 84 on penalties leads that member states shall lay down the rules on penalties, in particular for infringements which are not subject to administrative fines. The directive lays down in Article 24 on sanctions that the member states shall adopt suitable measures to ensure the full implementation of the provisions of the directive, in particular laying down the sanctions to be imposed in case of infringement. What should accountable data controllers and processors get prepared for? They should know that the determination of administrative fines by national supervisory authorities is framed by the GDPR so that it will be consistent across EU. The assessment of the level of penalties will be based on each individual case. Penalties in the GDPR will be effective, proportionate, and dissuasive, getting up to 20 million euros or 4% of the annual worldwide turnover of the preceding financial year. The fine for several infringements cannot exceed the one of the gravest violation. The set of criteria taken into account to determine the level of fines to impose is the nature, gravity, and duration of the infringement, intentional character of the infringement, the actions taken to mitigate the damage suffered, the degree of responsibility, previous infringements, degree of cooperation with the supervisory authority, categories of personal data affected, notification of the infringement to the supervisory authority by the controller or processor concerned, compliance with measures ordered by the authority, adherence to a code of conduct, and any other aggravating or mitigating factor. Member state law can frame administrative fines imposed on public authorities and the deprivation of the profits for private bodies. Supervisory authorities' right to sanction is subject to appropriate procedural safeguards, that is to say, effective judicial remedy and due process. Estonia and Denmark, finally, have specific process to put in place. So the question now is knowing more about EDPB guidelines on fixing administrative fines.